Special counsel Jack Smith asked Supreme Court on Monday to decide whether Donald Trump has any immunity from criminal prosecution for crimes he allegedly committed while in office. This is first time High Court will weigh in on historic investigation into former president. The extraordinary request is Smith's attempt to keep his lawsuit to overturn the election, currently scheduled for early March, on track. Smith is asking Supreme Court to take rare step of bypassing federal appeals court and quickly decide a central issue in case against Trump. Smith's team asked the court to review District Judge Tanya Chutkan's ruling that Trump, as a former president, is not immune from a lawsuit to overturn the election filed in Washington, D.C. The former president's lawyers argued that Trump's alleged actions related to the 2020 election results were part of his official duties at the time and were therefore protected by presidential immunity. Prosecutors also asked the court to decide whether Trump is protected by double jeopardy. Defense attorneys argued that Trump cannot be tried criminally for same alleged acts because he was acquitted by the Senate during impeachment trial. Later Monday, the Supreme Court said it would expedite consideration of Smith's petition to rule on whether Trump deserves immunity. Trump has until December 20 to respond. As President Trump has said repeatedly, this investigation is purely politically motivated, a Trump spokesman said in a statement Monday. If Supreme Court were to take up case issue of presidential immunity would not be decided by appeals court. The issue of presidential protections, which Trump hopes use as part of his defense, needs to be resolved before he goes the hearing scheduled for March. Defendant's appeal of order denying his immunity and related allegations suspends the trial of charges against him, which is scheduled to begin on March 4, 2024, Smith's team wrote. The file continues as follows, according to decision of the regional court. Defendant's allegations are extremely flawed. However, only this court can resolve these once and for all. USA v. Reminds me of Nixon. The special counsel team was involved. US v. The 1974 Supreme Court case, in which the justices rejected then-President Richard Nixon's claims of presidential privilege, a subpoena fight over Oval Office tapes. He points to a similar maneuver employed in the Nixon case. In this case, High Court quickly resolved the matter so that one of Watergate-era cases could move forward quickly. Historically, the Supreme Court has rarely accepted this kind of gamble, taking up an appeal before the Federal Appeals Court has had a chance to do so, said Steve Vladeck, CNN Supreme Court analyst and University of Texas professor. But not only has the court shown itself be much more willing to expedite appeals since 2019, and even before then, but this was exactly the type of case it would agree move quickly, Vladeck added. In their